Hi, I'm Carrie Sperling, Director of the Wisconsin Innocence Project. Brian Stevenson has said, our criminal justice system treats you better if you're rich and guilty than if you're poor and innocent. Nowhere is this more apparent than in our cash bail system, a system that forces people that are presumed innocent to await trial while locked behind the bars of a county jail. Today, my students and I will show you how cash bail leads to wrongful convictions, and we'll argue that now is the time for serious reform.
Thank you, Carrie. My name's Emily Bain, and I'm a law student at the University of Wisconsin Law School, working with Carrie at the Wisconsin Innocence Project. My classmates Mackenzie Ahmet, Stephen Shee, Sarah Molick, Madeline O'Connor, and Michael Oden and I have spent the last several months researching and examining the relationship between cash bail and wrongful convictions in the United States. Today, we'll be featuring interviews with Professor and author Alexandra Natapoff and Professor Michelle Levine. But right now, we would like to start with the voice of one of our exonerees, Dan Scheidel, whose entire case and life was transformed by a bail decision. Michael Oden interviewed Dan about his experience.
With us today is Dan Scheidel, a 2017 exoneree and former client of the Wisconsin Innocence Project. I wanted to first ask about how bail impacted your case. Looking through the records of your bail hearing, bail for you was set at $125,000. The defense lawyer noted that it would be, quote, of tremendous assistance to me if my client would be out in this case because there's investigation yet that needs to be done. How deeply was your case impacted by your being in jail? What was it like trying to speak with your attorney? To what extent were you able to mount a defense while in jail?
It was very difficult. There was no way that we could have posted the bail. When I was originally arrested, morning of May 20, I was told the bond would be $20,000. And on Monday morning, went before the court commissioner and learned that suddenly it was $125,000. Being out to assist, it's so hard to reach an attorney to tell them a thought or to express an idea. Visitation with attorneys is sometimes limited. It's a very uncomfortable situation, at least in our case, because the interview room was directly next to the guard station. You could hear the guards through the wall and window. So I'm pretty sure they could also probably hear us. It's a very defeating feeling because you walk into the interview room, you walk out of the interview room the same way you walk in, not really knowing what's going on.
When you were making your appearances in court, what was the process like being moved between the jail and the courthouse?
Which means you are shackled, handcuffed, shackles and waist chains attaching you to the other inmates. You're led through a tunnel under the street to the courthouse. And you could sit there for, if your case is called first, you might be sitting there until 1 o'clock in the afternoon waiting for the other defendants to finish their hearings. So yeah, it's extremely uncomfortable. Also the fact that people are in, some of the other defendants are seated in the jury box, so they're listening to everything. So of course you go back and everybody's talking about what just happened.
I wanted to ask, when you knew that you were going to prison, what happened with all of your possessions and what happened with your home?
I was very fortunate. My family packed up my apartment. They put everything in storage. My possessions were in storage for about 21, almost 22 years. It's rather funny because when I went to the storage locker and opened it up, the first thing I saw sitting right at the very front was a wicker laundry basket filled with toilet paper. And I just found that very funny, and that kind of broke the tension for me a little bit. It was rough because my mother passed away while I was in prison, so there were many things of hers, papers and books and other possessions of hers. That was tough going through, and it's kind of a slow process.
In prison, while you were being treated for cancer, how were your medications handled?
All medications that are any type of opioid or controlled medication, you have to go to the health service unit 3 times a day, after count in the morning, after count in the afternoon, and then I think it's 8:30 to 8:45 in the evening. And you have to put on your coat and slug through the snow or the rain or whatever and go up there and stand in line to get your meds. In the hospital, of course, things were handled much differently. It was much more professional as far as what you would think of a hospital stay. Of course, you were shackled to the bed again, and you had at least 1, if not 2, correction officers in the room with you at all times. So, yeah, it was a strange feeling. And then when I came back to Racine County, there was such a problem in getting medications. I was on pain medications 3 or 4 times a day. They only wanted to do it twice a day. And I had to get the attorneys from your group involved and in order to get my medications. That was rather difficult.
Building off of that, what was it like to get surgery while you were incarcerated?
That was rough. When you go through any type of devastating medical procedure or disease, you're basically doing it alone. Your family is not allowed to visit. They don't even know where you are. They'll tell you you're hospitalized, but they can't tell the family where you are or what's going on. That was tough. It turns out that your support system is correctional officers. And over a period of time that I'd been at RCI, I'd gotten to know many of them on a casual level. But when you're going through something like that and they're taking you to Madison every day for 30 days in a row for radiation therapy, or you're going up for an extended stay while you're receiving chemotherapy, and that's the closest thing you have to support. You can't talk to friends or family. You're there.
When your conviction was vacated in 2015, but you had to return to the county jail, what was that experience like?
That was strange. Newspapers are available in jail, also in prison. Generally, it's because the inmate or the holdee, whatever the case might be, family or friends send the paper in. They sign up for a subscription and you get it. When I went back to the county jail, I think I spent 3.5 days in a holding cell, which meant the cement block, laughingly called a bed, 1 very thin blanket, and a light that was never turned off. When I went up to the pod then, everybody in there knew who I was because it had been, something that had been in, and it got around pretty quick. So that was, I hate to say it, it sounds horrible, but in a way it's the judicial system, almost a badge of honor. And there were so many questions, and of course the main thing is you don't talk about your case right after you're arrested, during hearings, during a trial, after sentencing, whatever. It's people are going to use anything they can against you.
Lastly, I want to ask, as a whole, how would you compare the experience of being in prison versus being in jail?
Night and day. Jail is the most horrible time any person can do. It's demeaning. It's you're in a pod with anywhere from 8 to 16, 18 guys. Some are double cell, double bunks. Otherwise, with the overcrowding, they would throw what they call the boat, a little plastic shell with a mattress in it, or just a mattress on the floor. It was very demeaning, the entire thing, the entire time. The day I was, it was a Sunday morning, I was woken up about 4 a.m. and they said, well, you're going to RCI, Racine Correctional today. And it was like, almost like a shroud was lifted. It was like, yes, I can't take any more of that. You treated, I know it sounds strange, but you treated more like a human being in prison than you are in a county jail.
Well, thank you very much. I want to say thank you again for speaking with us today and sharing your story and your experiences. Your story is a powerful one, and it sheds a lot of light on the injustices that come from wrongful convictions. So thank you again for joining us today.
Thank you, Michael.
Dan's story is compelling enough to make anyone question why we have bail in the first place. So let's start from the top. What exactly is bail? It's the amount of money an accused individual must post to be released from custody until their trial. It's set in an attempt to ensure the accused will show up at their trial and any subsequent hearings. If an individual cannot post it, they will be sent to jail until they can pay it, or until trial. A judge determines the amount based on a variety of factors, which retired University of Wisconsin Law School professor and bail expert Michelle Levine, along with Alexandra Natapoff, a Harvard law professor, will expand upon in the next clip. Professor Natapoff is a well-known author of 2 essential books that relate to our topic: Snitching, Criminal Informants and the Erosion of the American Justice System, and Punishment Without Crime, How Our Massive Misdemeanor System Traps the Innocent and Makes America More Unequal.
How are the amounts determined?
I don't know. Do you know what an 8-ball is? You know, that toy? Yeah, right here. You know, ask again at a later date, you know. They are not, courts are not supposed to have set amounts. There is what's called a bond schedule for people who have been arrested. There's a fixed amount in misdemeanors that they can post before they have to go to court. But that's not what we're talking about. Here, the judge is supposed to make a determination what amount of money, if any, is necessary to assure your appearance. That's the whole point. Some judges say really nothing, you know, nothing. And it's true. There's a whole lot of people for whom you really don't have to do anything. They'll come. Other people, they have these funny amounts, like $50. You'll see the commissioner or the judicial officer refer to it as having skin in the game. You have to have some skin in the game. So $100. And what they're trying to assess there is the risk of non-appearance. Well, $100. I mean, you start to understand. I mean, if somebody's dirt poor and has nothing, they're not going to get out. The flip side is that that's a small enough amount of money that if somebody doesn't want to come, it's not going to be, you know, somebody posted $100, I'd better go.
And the great conversation that we are now having in this country with bail reform in so many jurisdictions is the recognition that bail is a very different proposition for poor people and working people who don't have the money than it is for wealthy people who can make bail, as they say. And in effect, we are locking people up, not because they're dangerous, not because they're a flight risk, not because they're terrible, but because they can't afford to pay whatever the amount of money is that the court has set. So that's bail.
The federal right to non-excessive bail is guaranteed by the 8th Amendment, with almost all state constitutions granting similar rights to defendants. The controlling case is United States versus Salerno, which affirmed the constitutionality of detaining someone pre-trial for public safety reasons, while also claiming that in our society, liberty is the norm, and detaining someone prior to trial is a carefully limited exception. but that rarely is the case. Pretrial detainment is not a limited exception. So now I want to ask my Wisconsin Innocent Project colleague, Mackenzie Ahmet, to share with us some of the statistics surrounding bail. So Mackenzie, how many people are detained pretrial?
Thanks, Emily. When we look at some of the statistics surrounding bail and pretrial detention, it becomes clear how vast this problem is and how many people the bail system impacts. Of the 746,000 people currently being held in local jails, roughly 63% have not been convicted of any crime. These 470,000 non-convicted individuals are awaiting trial on issues ranging from violent crimes, such as murder, to mere public order violations, such as driving with a suspended license. Clearly, the amount of individuals currently incarcerated without conviction is massive. Why are so many people detained pre-trial? Many of them cannot afford bail. As we learned earlier, it's the judge's job to determine and set bail. Consequently, bail amounts vary in each case. The national average bail amount for a felony case is $10,000. For misdemeanor offenses, average bail ranges from $200 to $1,000. However, the expenses don't stop there. There are numerous costs associated with bail. These are often referred to as hidden costs, as they are not readily apparent when bail is first set. Associated costs can include court costs, bail bond premiums, electronic monitoring fees, credit card fees, and travel fees. These associated costs can sneak up on those seeking to pay bail. And what's more, these associated costs are usually non-refundable. Remember that at this time, individuals out on bail have not yet been convicted of any crime. So, as we've discussed, bail is expensive, but what can the average person even afford? Federal studies indicate that nearly 40% of Americans would have trouble finding just $400 to cover an emergency. This number is far below that $10,000 average for felony charges. To visualize this issue, we can look at this chart. As you can see, the average annual income for those able to afford bail and get out of jail while awaiting trial far exceeds the annual income of those who must remain in jail. This illustrates how wealth is a determinative, crucial factor in whether someone will be able to await trial at home or whether they will remain incarcerated for weeks or months before trial.
Thanks, Mackenzie. Now I want to introduce my colleague, Stephen Shee, another law student in the Wisconsin Innocence Project. Stephen, can you share with us some data about how frequently bail is assigned?
Thank you, Emily. The Hamilton Project pointed out that the court's increasing reliance on monetary bail over non-financial release options partially explains the rise in pretrial detention. Using data from the Bureau of Justice Statistics, this figure breaks down the population of felony defendants in a sample of the nation's most populous counties by their pretrial release outcomes from 1990 to 2009. Most importantly, this figure shows that the overall share of defendants required to post bail increased from 53% in 1990 to 72% in 2009, while the share of defendants released without bail went down by 15%. The court's reliance on monetary bail has far-reaching consequences. In addition to more people detained in jail before trial, people are also spending more time in jail. As seen in the figure, this increase can be observed across the board for different felony offenses. Some of the critics' biggest concerns on bail reform are the likelihood of defendants missing court appearances and the danger to the community. But the most recent data from BJS suggests that these concerns may not be as significant as some claim to be. 83% of felony defendants did not miss court when they were out on bail before trial.
Thanks so much, Stephen. Next, we'll hear again from Michelle Levine about how pretrial detention impacts the quality of legal representation and frequently leads to wrongful pleas.
What's the worst case you've seen of a bond amount causing real problems for a defendant?
It actually wasn't my case. It was one of my students. And it was a student who just started in February in Kenosha. She's never bored, let's just say that. So they were running around like every place. When COVID, we finally figure out what's going on with COVID. They're running around trying to get people out. She had a guy in jail, $50 for operating after revocation. $50. He was in for 30 days. For 30 days, and she had to basically beg and plead to get him out.
That's driving without an expired license.
With a revoked driver's license. All right. I don't care if it's his 98th offense. What are we doing? What are we doing? He hasn't been convicted, but we're going to hold him 30 days for driving.
Why would that request be denied if someone's being held just because they can't afford to pay $50?
Well, the 50, yeah, I don't know why. Because we're mean. I don't know. They're just like, well, no, we just think that's what's necessary to assure his appearance. You got 30 days out of the guy. I mean, you want to change in circumstances? He has now done 30 days. How much time do you think he's going to do if he's convicted? What are we doing? One of the things they've done where bail is an issue, California, I know this was an issue. You can only hold them if you've got to make a specific finding that they're dangerous. Well, I see the problem, and one of the big problems is, who are we finding dangerous? Why are we finding them dangerous? But that's what a lot of this stuff is about in the first place. And so let's be honest. Let's be honest. But we have very little data on who's getting cash. Why are they getting cash? One of my favorite stories is sitting in Sheboygan watching initial appearances, and there was an African-American man from Milwaukee. Milwaukee is 40 miles down the road from Sheboygan. Those of you who are from Wisconsin know this. It's not far. He's from Milwaukee. He's a greater risk of non-appearance. That's insane. That's insane. Let's get rid of that. Let's start taking a look at what do we really know about who appears and who doesn't appear. What makes you less likely to appear and what does not? Being from Milwaukee, I'm pretty sure doesn't have much to do with anything.
Now we want to pivot a bit to discuss the issue of jailhouse informants. Jailhouse informants are a leading cause of wrongful conviction, and excessive bail exacerbates the problem. Professors Nadapoff and Levine elaborate in our next clip.
Bail is a mechanism through which the government, by seeking very high bail, can ensure a defendant's detention, or put pressure on a defendant to be incarcerated, where they might then be exposed to jailhouse informants who could come up with information or allege either an actual or a fabricated confession. And so the intersection of the government's ability to seek high bail as a way to ensure incarceration so that a defendant might be subject to essentially a covert kind of interrogation by a jailhouse informant, I would see that as a larger dynamic. It's not just of benefit to the individual jailhouse informant, although of course it is, but they are one piece in a larger puzzle about how we permit the pretrial process and the negotiations around guilt and information and liability in our plea bargaining to really shape outcomes in a profound way that I think flies under the radar much of the time.
Informants are a scourge. You might, take a look out at Orange County, California to see how they are. They are known for their, willingness to lie, to sell their mother or their daughter or their cousin or anybody. But the only way that works is if somebody's in jail on bond, unable to post. That's the only way that works. I mean, yes, you can, I guess you can get a neighbor to agree to, to turn state's evidence, but in jail where you've got an individual, an informant who's got every reason in the world to cooperate because there's something in it for him or her, and overwhelmingly it's him. Sorry, guys, but overwhelmingly it is. So they're in there as well, and then they start to move these people around. And there are some people, they are just professional snitches. They just are. they show up all over the place. It's like, oh, you again. You know, and the idea that, and these guys are good. They're good. They're, you know, it's almost irrelevant whether the client talks to them or not, because they get the documents and they're good at telling that story. And so, of course it happens. That's where it happens, is in jail when somebody's held on bond.
If you can't make bail, you're going to stay in jail for weeks or months until your case is resolved, which means the pressure on you to plead guilty is enormous. And that's, in a nutshell, where we see wrongful misdemeanor convictions generated because of the inability to pay bail. If I'm arrested on a misdemeanor conviction and I don't have the $500 to make bail, the pressure on me to plead guilty so that I can get out, go on probation, face a fine, but because the amount of time that I would serve would be so much less, the pressure on me is enormous. I may lose my job, I may have children, all kinds of terrible things are going to happen to me because I'm incarcerated, and pleading guilty gets me out from under my inability to pay bail. And that is the linkage between poverty, bail, and misdemeanor wrongful convictions, because the pressure on poor people to plead because they can't afford bail is enormous.
As we continue to draw the line between excessive bail and wrongful convictions, I want to ask my fellow Wisconsin Innocence Project colleague, Sarah Malik, about who profits from the system and why do some people choose not to post bail?
Many entities profit from bail. The bail bond industry and their insurance companies profit the most from the current system. At the moment, the bail system is comprised of 9 major companies, which make over $2 billion a year. Another industry which profits is the private jail system. A vast number of the incarcerated individuals in this country are detained purely because they cannot make bail. As the jail population increases, so does the jail funding. Additionally, governmental entities profit from bail. Tough-on-crime politicians gain support through detaining high numbers of supposed criminals through bail. Also, state, city, and county governments profit from the incoming funding from forfeited bail money. Another question we face today is, why do people choose not to post bail? Well, as we have recently established, many individuals cannot afford bail whatsoever. For some, even the lowest bails are unaffordable. However, many people would financially be able to make bail, whether through external help or putting up collateral, but choose not to. A major reason why individuals choose not to post bail is because the ability to afford bail may preclude an individual from obtaining a state-appointed defense attorney. Many individuals cannot post bail and afford a private attorney. Another reason why people may choose not to post bail is because commercial bail becomes extortion to a point. Bail bond companies can put extra restrictions onto an already existing court order. Under these extra restrictions and fees, there is a heightened daily threat of having the bondsman return one to jail.
Thank you, Sarah. Now I'd like to ask Madeline O'Connor to discuss some recent developments in various jurisdictions' attempts at bail reform.
Thanks, Emily. A few states have tried to overhaul their bail systems in recent years. In 2017, New Jersey replaced cash bail with a risk assessment tool. The reform has been highly successful. By the end of 2018, New Jersey's pretrial jail population had fallen by 44%, though the racial disparity was unchanged. Critically, the New Jersey law led to no significant increase in rearrests of defendants released pretrial or missed court appearances. California and New York both tried reforms with less success. California SB 10 was passed by the legislature and signed by the governor in 2018, but its implementation is on hold pending a voter referendum promoted by the bond industry. New York passed an overhaul of its bail system earlier this year, but rolled it back after political backlash. In light of this setback, advocates in other states are adjusting their approaches to secure more buy-in from police and prosecutors and provide more public education.
Right now, we are a very, very mean place. And I don't just mean Wisconsin, not by a long shot. We would rather err on the side of locking somebody up and they're not committing new crimes. And if you take a look at the comments that arise when somebody's held on high cash bond, well, he did X. He hasn't done anything yet. It's an allegation.
we're very, very mean. Our system is very retributive, very harsh, and that starts at bail.
We hope you now see that our current bail system contributes to wrongful convictions. Thank you so much for the privilege of your time and for participating in the Innocence Network's Wrongful Conviction Day.